Okay, welcome everybody to our monthly So Now You Know webinar, where we discuss an interesting legal topic in a bit more detail so that all you fine people out there can benefit. Today, our topic relates to the structuring of non-profit companies. But before we get there, a little bit more about legalese. Legalese is a creative legal practice which has redesigned legal legal services to suit creative, startups, and tech-based businesses by making them accessible, affordable, and understandable. Traditionally, lawyers are called to fix problems, but legalese looks at the law differently. We have a fresh approach to law and technology so that our legal solutions fit your business, team, and culture. So a little bit more about me. My name is Kyle Freitag. I am the head of commercial law as well as the head of our gaming department. I assist our clients with all of their legal needs, from drafting contracts, advising on internal structuring, and everything in between. We do our best to be a one-stop legal shop for our clients. So what are we talking about today? So today we'll be talking about some of the considerations that you need to take into account when planning out or structuring your nonprofit company or group of companies. We'll cover where and how structural changes are brought about. We'll discuss group structures, setting up appropriate relationships, some multi-jurisdictional considerations that you might need to take into account, as well as public benefit organizations and Section 18A status. All right, so first up, exactly where and how are structural changes made? How are they brought about? What do you need to take into account? And what legal factors have an impact on your decisions? So the main part of your structure will be set out in your Memorandum of Incorporation, or MOI. This is the foundational constitutional document relating to your company. And everything else, including agreements with third parties, the manner in which you run your NPC, and any other relevant considerations must be consistent with its terms. This means that it's incredibly important to appropriately define how the NPC functions in the MOI itself. Schedule 1 of the Companies Act 71 of 2008 generally contains provisions concerning nonprofit companies. This is a very important text that everybody who is involved in an NPC should read and understand. So turning a little bit to objects and policies. Now, when we talk about objects, we aren't talking about tangible or movable property. We're referring to the philanthropic or beneficial purpose for which your NPC has been established. Your MOI must set out at least one object of the company, and each object must either be a public benefit object or must relate to one or more cultural or social activities or communal or group interests. The objects and policies must also be consistent with sub-items 2 to 9 of Schedule 1 of the Companies Act, which broadly speaking deal with aspects like how and to whom an NPC can pay their income or transfer their assets, what happens when the NPC is wound up or dissolved, and similar items of that nature. It also introduces the concept of incorporators and members, as well as fundamental transactions, which we'll deal with in the next 3 slides. So very simply, incorporators of an NPC are its first directors and its first members, if the MOI provides for the NPC to have members. Turning to members, an NPC is not required to have members, but its MOI may provide for it to do so. However, there are always rules around this sort of thing. So your MOI must not restrict or regulate that membership in any manner that amounts to unfair discrimination in terms of Section 9 of the Constitution. Section 9 of the Constitution lists grounds like race, gender, sex, pregnancy, sexual orientation, marital status, ethnic or social origin, etc. Further, your MOI must not presume the membership of any person. You can only award membership for service to either the company or to the public benefit objects set out in the company MOI, and crucially, with that person's consent. Your MOI may allow for members to be juristic persons, so companies, trusts, etc., can also be members of your NPC. And further, your MOI may allow for no more than 2 categories of members. Those can be voting and or non-voting members. So you can have voting members and non-voting members. You can have voting members or non-voting members. Your MOI must also set out the qualifications, application process, costs, rights and obligations that are involved in or are required for being a member, as well as the grounds on which the membership may or will be suspended or lost. Very importantly, if an NPC has members, you need to keep a register of those members, similar to how a profit company keeps a share register. Turning to fundamental transactions, NPCs may not amalgamate or merge with or convert into a profit company. They may also not dispose of any part of their assets, undertaking, or business to a profit company other than for fair value, except to the extent that the disposition of those assets occurs in the ordinary course of business. So if the NPC sells stuff, if the NPC gives products away, you cannot do that other than in the circumstances of where it's in your ordinary course of business. If an NPC has voting members, they must be able to vote on any proposal to dispose of all or the greater part of the NPC's assets or undertaking, or the amalgamation of or merger of the NPC with another NPC. You'll remember in the first point, I said that NPCs may not amalgamate or merge with a profit company. They may, however, do so in relation to another NPC. In relation to group structures, it is a requirement that an NPC must not directly or indirectly pay any portion of its income or assets to any incorporator, member, director, or person appointing a director, except in certain limited circumstances. These are set out in Schedule 1, Item 1, Sub-Item 3 of the Companies Act, which, as I said, everybody who's involved in an NPC should be reading Schedule 1 of the Companies Act because it contains extremely important information. So from my first point, it's quite clear that you cannot run a for-profit business through an NPC. It's also baked into the name. A non-profit company, where you would assume that you cannot run it for profit. What some people do in this regard is to create a group structure whereby an NPC and a for-profit company run alongside one another. In these circumstances, it's quite important to align all the entities in the group around the holding of intellectual property. For example, who's going to own the name, who's going to own the logos, who will be the holder of the trademarks. And the last point, most crucially in my mind, is that money flowing between the entities in the group requires clear guidelines as to how and why that money is being paid. This is very significant because depending on your status as a public benefit organization or on your public interest score, or simply the requirements of your funders, you may need to undergo an auditing process, and you need to be able to explain how that money flowed from one group, from one member of the group to the other. So let's talk a little bit about setting up appropriate relationships. There are a few different aspects to this. So I'm going to be talking about board composition. I'm going to be talking about funding relationships. And lastly, I'm going to be talking about relationships with other role players. So let's talk about board composition. In terms of MOI requirements, if your company has members, you must set out the basis on which the members can choose the directors. And if that basis involves election by voting members, it must provide for the election each year of at least 1/3 of those elected directors. If a company has no members, the MOI must set out the basis on which those directors are to be appointed by the board or other persons. So let's talk a little bit in these circumstances about what an NPC may not do in relation to a director. So an NPC may not provide a loan to a director. NPCs may not secure a debt or obligation of a director, or otherwise an NPC may not provide direct or indirect financial assistance to a director. This includes directors of related or interrelated companies, or to a person related to any such director. So it's not a director's family member similarly can't obtain financial assistance from an NPC. Very important to establish, it's very important to establish a contractual relationship with the director or between the director and the NPC in order to ensure that the director's roles and responsibilities are mapped out and that there are tangible and measurable outcomes of what the director should, of the roles and responsibilities of the director. Directors of NPCs are subject to the requirements of the Companies Act around director liability and their relationship with the NPC. People tend to think that because the NPC is an entity that's not generating a profit, this relaxes the rules around things like the fiduciary duty that a director owes towards the company. This is otherwise known as the duty of good faith. It's basically the requirement that a director of a company, or an NPC in this case, would need to act at all times in the best interests of the company. The fact, what people think is that because the NPC is not generating profit, it relaxes those rules, but that is categorically a fallacy. These things do apply and are actionable at the instance of the NPC if a director breaches their duties. Directors should be independent people who can potentially offer useful services or who can further the objectives of the NPC. So a lawyer, an accountant, somebody who is involved in the sort of social benefit that you guys are trying to establish with your NPC, and who's well known for being very capable in those circumstances. These are all people who would be very good directors to have on the board. Now, the tendency is to try and engage famous people to sit on the board of directors, but famous people are typically quite busy and unable to engage in the day-to-day running of the NPC that might be necessary. So in those circumstances, I typically advise that for the creation of an advisory board to house people like that. These are not formal office-bearing directors. It's more of a loose ad hoc relationship whereby the well-known or famous person can be akin to like the face of the company. In doing so, they can provide their knowledge or skills or access to their following that you might require, without the ongoing legislative requirements and without them being subject to ongoing and potentially administratively burdensome work for the NPC. So let's talk a little bit about funding relationships. It is crucial that you know and understand the requirements that a donor or funder might have before you agree to take their money. These must be set out in some kind of written agreement between the parties. And this is important because these requirements can include pretty much anything from ownership by the funder of intellectual property to audit requirements, like I mentioned earlier. So it is extremely important that you're aware of this. Certain investors, for example, the South African government or institutional investors, might require certain registrations. These can include registration as a public benefit organization, or if you want to obtain grant funding from the government, you need to register with the Department of Social Development. You also need to have a robust, transparent structure to be attractive to potential donors or funders. But it is important to strike the balance between transparency and the ability to have good operations. A poor structure will hamstring your operations, while a robust structure will cater for both transparency and efficient operations. So then let's talk a little bit about some multi-jurisdictional considerations. So if, for example, you have a global entity that's wanting to start up a branch in South Africa, thought needs to be given to how the local entity will tie in with the global entity. The global entity should have the right to disassociate with the local entity if necessary for any reason. Some of the reasons could be poor management or bringing the brand into disrepute. And in those circumstances, the global entity might want to dissociate themselves from the local entity to protect their brand and to avoid having their brand being brought into disrepute. It's a good idea to contractually bind the local entity, either through contract or ideally by incorporating the relevant terms into your MOI. And importantly, you need to have consequences for a breach of those terms. So next, we're going to be discussing public benefit organizations and Section 18A status. So in order to be considered a public benefit organization, you need to perform a public benefit activity, which public benefit activities are listed in Part 1 of the ninth schedule to the Income Tax Act. And this whole framework is set out in Section 30 of the Income Tax Act as well. Section 18A of the Income Tax Act, which people might have heard of before, allows successful applicants to issue receipts that allow donations made to them to be tax deductible by the donor. You must also perform a public benefit activity, but those public benefit activities must be listed in Part 2 of the ninth schedule to the Income Tax Act, as opposed to Part 1 in the circumstances where you're just applying to be considered a PBO. Crucial to note here that just because you have applied successfully to be a PBO, it does not mean that you automatically have Section 18A status. It's also not guaranteed that just simply by virtue of that fact, you will be granted Section 18A status. So for both of the procedures that I mentioned on the last slide, it requires the foundational or constitutional documents of the NPC, for example, the MOI, to contain certain rules and submissions. It is advisable in these circumstances to enlist the services of a lawyer to ensure that the letter of the law is adhered to and that your documentation is prepared correctly for submission to SARS to maximize the chance that your status or your status as a public benefit organization would be approved. So a bit short and sweet today, but today I've taken you through a brief introduction to NPC structuring. I've given you some context on structural changes and how they're brought about. We also discussed group structures a little bit and setting up appropriate relationships. And we further touched on multi-jurisdictional aspects, rounding off with PBOs and Section 18A status. So please don't hesitate to let us know if you have any questions, comments, or concerns in relation to the discussion today. Here are our contact details. We're on Facebook at Creative Legal Solutions. We on Twitter at legalese_SA, on Instagram at Lawyers of Legalese. Our website is legalese.co.za, or you can simply email us at info@legalese.co.za. And that is it for me today. Thank you for your attention and thank you for joining. If you have any questions, please don't hesitate to get in touch with us. We'll be very happy to field any questions that you guys might have. And we look forward to hearing from you. Thank you very much.